My name is Gail Aldrich. I'm an AARP board member, and I'm pleased to testify today on behalf of older workers. Older workers have long been an AARP priority, and roughly half of all AARP members are employed either full or part-time. We advocate for older workers in Congress and before the courts to combat age discrimination. In addition, AARP participates in the Senior Community Service Employment Program. We annually recognize best employers for workers over age 50, and we organize job fairs, allowing employers and older workers to find one another. Before I became an AARP board member, I was a business executive, responsible for applying federal and state employment laws on a day-to-day basis. I previously served as Chief Membership Officer of the Society for Human Resource Management, and I have been the top HR officer for 3 organizations. As a result, I'm very familiar with the challenges of addressing age and other discrimination claims by employees. I want to thank you and all members of the Education and Labor Subcommittee for extending AARP this opportunity to speak on the issue of protecting older workers against age discrimination and about the proposed legislation to address the U.S. Supreme Court's very troubling decision last year in Gross v. FBL Financial Services. AARP thinks the decision is wrong and that the court's interpretation of what Congress meant when it enacted the ADEA is inaccurate. Unless corrected, this decision will have devastating consequences for older workers. The decision could not have come at a worse time for older workers who are experiencing a level of unemployment and job insecurity that has not been seen since the late 1940s. This decision takes away a vital legal protection at the very time that the economy does not give older workers the luxury of ignoring the discrimination and simply finding another job. The unemployment rate for people over 55 has more than doubled since the start of the recession, rising from 3.2% in December of 2007 to 6.9% in March of 2010. Once out of work, older workers or older job seekers face a prolonged and often discouraging job search. The average duration of unemployment has soared since the start of the recession and is substantially higher for older job seekers. Over half of job seekers over age 55 are found among the long-term unemployed, those who have been out of work for 27 weeks or more. Once out of work, older persons are more likely than younger unemployed to stop looking for work and to drop out of the labor force. Older workers need effective age discrimination laws when employers choose to displace them based on their age due to stereotypes rather than performance or other legitimate business reasons. And clearly unfounded stereotypes about older workers linger. AARP attorneys have battled employer perceptions that older workers have less energy and are less engaged, despite our research at AARP showing that actually older workers are more engaged in their jobs and are more reliable. Some employers believe older workers are a poor investment for participation in training. However, AARP research shows that they are more loyal to their current employers and may be better training investments. And finally, some employers have outdated notions that older workers are unable to adapt in industries like computers and information technology. This despite us baby boomers who are enthusiastic about embracing all kinds of rapidly changing IT products and services. Failing to allow older workers a fair chance to fight age discrimination is directly contrary to other federal policies envisioning that Americans will work longer. For instance, the 1983 Social Security amendments increased the age of eligibility for full benefits to be paid. Eliminating discrimination is critical if older workers are to delay their date of retirement. Working longer is good for society. It's because earners typically pay more in taxes than retirees. It is also good for workers who have more years to save and less time in retirement that they have to finance. And it is good for employers who retain skilled and experienced employees. AARP strongly favors and endorses H.R. 3721. It would eliminate the second-class status for victims of age bias that the court in the Gross decision seemed to embrace. In the worst economic conditions in decades for older workers, Congress should act now to correct this misguided ruling. Thank you.